Hello, hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we are continuing with our very interesting discussion about things that lawyers do with estate planning that might qualify as either sloppy or shady or shifty, as we might want to say.
Or sketchy or
Or
whatever.
sketchy.
Or we don't like it.
Right.
Either way, I don't like it. So now that we've talked about trusts in the previous video, we've talked about trustees, lawyers appointing a certain companies as trustee. I want to talk about the will.
Ooh,
because
yes.
a will is a big way to be sketchy or shady. So one of the ways that some law firms can be sketchy with regards to wills is totally relying on them. Let's say they have a client. I have all these properties. I have millions of dollars. I have children from different marriages. I have all of these things that would send out alarm bells in our heads. And the lawyer goes, all right, sounds good. Here's a will. I'll have $1,000. Call it a day. To us, that makes us cringe.
Yes.
But to that lawyer, what he's seeing is a 80-year-old man on his deathbed who has all these properties, who is going to be an incredibly lucrative probate for him within the next 5 or 10 years.
Yes.
And so that money, that $500, that $1,000 that he's charging for the will now, is going to be perhaps $100,000
yes.
a few years from now. So he's planting seeds.
Right.
And so depending on the intent of it, a situation like that, and please, tell me something different, Kirsten. How many times have we heard that?
Oh, yes. I have had several phone calls over the years where people are saying, we don't have our original will because we called the law firm that did it and they kept the original wills and now they're out of business. And in fact, fun little story, I went down into the basement of this building when we first moved here, and there is a big cardboard box on the outside that says original wills.
Ugh.
I have no idea what attorney from 1970s or 80s or whatever was essentially keeping original wills. Now, I know from my ethics and that I got in law school that this practice of keeping original wills has been considered to be unethical in Wisconsin for a very long time now. But that doesn't mean that lawyers aren't still doing it. And so if ever you were to run into an attorney who suggests or asks that they keep the original will, that is unethical and that should not happen. Because why do you think? Well, if they keep the original will, you need the original will to submit to probate court regardless. And then they would clearly be getting the phone calls to do the probate, which then links right back into your story about how attorneys are planting seeds to then have these wills turn into very lucrative probate cases down the line.
Right, because why would any lawyer in their right mind say, okay, I can get you set up with a wonderful trust and we'll fund it correctly and I'll get everything transferred for you for $5,000, $10,000, $15,000, whatever it's going to charge based on the package, when they could say $1,000 now, $100,000 10 years from now when you die.
Right.
And so, and where it comes down to is ethics.
Yes.
Are you shady? Are you a shady attorney? Is that the kind of practice that you want to run? I prefer to get it set up for people so that they don't have to go through all that nonsense when they pass away. Because yes, if we were just solely business people and didn't care about our clients, heck yes, we'd do that. Mm-hmm. I would give out a will for free.
And you know what? That actually reminds me, there was an attorney that was at a large organization, and I happened to know some of the staff of this large organization, and they called me and they said, hey, we have somebody here at this organization that is willing to do anybody's will for free. What do you think? And the subtext of that was, are you willing to match that? And
I'll beat it.
I was like, No. And by the way, that's if it's not unethical, it's certainly borderline unethical because you don't have an attorney client relationship unless there is some kind of consideration, meaning money, that is given in exchange. And so to have a will drawn up where then maybe you're signing something saying, and I agree that I will use you for my probate is unethical.
Mm-hmm.
And I suspect that's what maybe he was doing.
So I'll use an internet term, Kirsten, that I know you're probably very familiar with. One of the internet terms now is that if you're not paying for the product, you are the product.
Ooh,
so that comes into fruition in the internet where all these websites are free, Facebook, Google.
Mhm.
If you're not paying for it, your data is the product. So in this situation where if you're not paying for the will,
Yes.
yeah, it's not that the will is free. No, they're going to come back and they're going to do a multi-$1,000 probate
Right.
once you pass away. So if you're not paying for it, you are it.
Interesting.
So
very interesting.
Lawyers aren't stupid. Lawyers also don't give away things for free.
Right.
Lawyers like to make money.
Right.
And so
Yes.
if you ever think, oh, this lawyer will do something for me for free, it's not because they're a humanitarian. It's because there's probably something down the road that is going to end up costing your family a heck of a lot more money.
So interestingly, another element of that is those lawyers who set up estates, maybe they are doing a trust. Usually it's a revocable trust, but they're relying on the pour over will to get assets into the trust after somebody passes away. Now, why is that a terrible idea?
That might actually be the worst situation because you've essentially created a testamentary trust at that point. Testamentary trust is just a trust that's created after you pass away. And so after a probate, then the stuff goes to the trust. So if you're just relying on a pour over will, the wonderful thing about pour over will is that it makes it so that I don't have to draft multiple trusts. I can just draft one trust, point to the pour over, here's how I want stuff distributed. However, if there's something in your individual name when you pass away, and in Wisconsin, if it's over $50,000, it's going through a probate.
Right.
Whether you have a trust or not, the only way it's not going through the probate is if it's in the trust. And so what a lot of shady or maybe sloppy attorneys don't do is that they'd say, no, you don't have to fund the trust. You don't have to put all your stuff in there. We'll just rely on the pour over will.
And it never works. I have a story where they set up the revocable trust and they had the house and they were relying on the pour over will to pour the house into the trust. And do you think that worked?
No.
Absolutely not. No, when they went to sell the house, the underwriter for the title company flagged it and said, we need a piece of paper from the court saying that it is acceptable for this to be sold by the personal representative because it is not yet in the trust. So that's what ends up happening is that then the asset is sold and then it is the personal representative who then puts it into the trust. And that's the point in time when the trustee takes over. So I'm trying to think of a time when it would be a good idea to rely on the pour over will to do things that you already know are needing to happen. And I quite frankly can't think of one. The purpose of a pour over will is quite different from that.
Right.
We do them, but we do them only as a stopgap measure. If, let's say, 3 days before I pass away, I get $1 million inheritance from my uncle that I didn't know was coming, and it's in my individual name. And so now there's no beneficiary designation for that asset. And so then it is a good thing that that pour over will was there because now that asset can be handled in probate. The pour over will pour it into the trust, which has my beneficiary designations already set up so that then there isn't any question about where my uncle's $1 million should go after it comes to me.
Right.
So there's an example of where the pour over will is good and makes sense. But if you know that the asset is yours already, there is no reason to not get it into that trust right away.
Right. And I think with that, the shady attorney doesn't put it in the trust on purpose,
Right.
so and doesn't educate the client to not put it in the trust on purpose so that they can have a bigger, more expensive probate.
Mm-hmm.
The sloppy attorney just doesn't know.
Just doesn't know,
Yeah.
doesn't understand it, hasn't done. Yeah, exactly. I completely agree.
Yeah.
So, speaking of sort of generally sloppy attorneys overall, I usually don't run into sloppy attorneys who only do estate planning.
Right.
The sloppy attorney is typically the one that also does criminal and traffic, real estate and divorce, you know, DUIs, and also, and I do estate
Right.
planning too, as though it can be part of a grouping of things that one attorney accomplishes.
Yeah, I got one trust 5 years ago from a buddy who used to work at a bigger law firm, and I just used that trust for everybody.
Yes.
One of those situations.
That's exactly right. Or I went to, how to build a small law firm or an individual law firm, and they said, oh, this is one of the things that you can offer. That is, in my opinion, not giving enough credence to the depth of knowledge that you need to have and keep up on in order to be an excellent estate planning attorney. Similarly, I would say the same thing for any of those one areas, because all of those are specializations.
Mm-hmm.
So,
yeah, and I think, especially if you're in a small town, and there's a whole lot of small towns up north in Wisconsin where they're significantly underserved attorney wise. And so I think if you're in a small town, depending on the kind of stuff you're dealing with, there's probably a lot of attorneys that say, I do a little bit of everything.
Right.
The thing is, estate planning, in my opinion, is not the area where that should be something that's a little bit of everything. You really need to be in this stuff every single day, year after year, constantly learning, because this is people's entire estate. This is all of their stuff. Whereas, if you do contracts once a week and you screw that up, that's one agreement.
Right.
That was screwed up for that one person. You could probably get away. A traffic ticket.
Mm-hmm.
You have enough experience, probably something you could do, some collections, some stuff here and there. But like, there's certain subjects that I don't recommend going to someone who's going to do a divorce on Monday, and then he's going to write your trust on Tuesday, and then on Wednesday he's got traffic tickets, and then on Thursday he's doing a variance for an ordinance, and then on Friday he's doing something completely different.
Right.
And so I think estate planning is the one where you want to go to someone who specializes in it.
I think so too. Well, thank you so much for joining us for part 2 of Shady and Sloppy Attorneys. And the reason we're doing this is not to be negative about other lawyers, but mainly to protect you, because we want to protect you today and tomorrow. Thank you so much for joining us, and we will see you next time.